Coming out of the New South Wales Land and Environment Court in relation to sentencing in particular is in 2008 they established the world's first environmental sentencing database, which provides very comprehensive overview of subjective and objective considerations as well as sentencing comments to provide a snapshot that allows for consistency, allows for an understanding of options, etc. Another example of why it matters to have a specialized green court or environment court is that we do see that the Land and Environment Court generally hands out higher sentences than our general courts, in part because at times there's jurisdictional limits on lower courts that doesn't allow them to exceed a limit that may be far less than what otherwise would be specified in the environmental legislation in relation to an environmental offense. And I guess the final innovation that I'll come back to at the end of my talk, again, harkens back to what Judge Stewart was mentioning earlier this morning, is the beginnings of restorative justice processes in New South Wales. Just by way of background then to the sort of Australian environmental offence landscape, just like in Canada, many environmental offences are not prosecuted. There is a whole ladder of enforcement options, many of them administrative, enforceable undertakings, penalty notices, etc. are used regularly, often leaving prosecution for the more serious breaches. The New South Wales the New South Wales Environmental Protection Authority prosecution guidelines make this clear. Even when there's sufficient evidence, as their guidelines say, the laying of charges is discretionary, and the dominant factor as to whether or not to proceed in the exercise of that discretion is the public interest. So there's definitely a recognition that prosecution is not always the appropriate response. Okay. But our question here, our focus is on sentencing, and so I guess as a starting question, and most of the speakers have referred to this morning, when a decision is made to prosecute an environmental offense, the question that we need to ask is, what is the prosecution and ultimately the sentence attempting to achieve? And under the New South Wales Crime Sentencing Procedures Act, there's a number of overlapping purposes that the court has to consider: retribution and punishment, denunciation, protection of the community, rehabilitation of the offender, restoration or reparation of any harm caused, but also deterrence. And while all are relevant, there is a particular focus on deterrence. So the New South Wales Environmental Protection Authority prosecution guidelines, for example, say, in criminalizing breaches of environmental law, a primary, though not the sole aim of Parliament, is deterrence. Deterrence both specifically of the offender and generally to deter others from the commission of similar offences. This seems to align with the approach of Canadian courts, and the objectives of the EEA are broader, but deterrence still definitely factors in there. Now I just added, I have to skip past this slide. I just added these two slides as Rebecca was talking because I thought it was interesting just from a comparative perspective to see what the New South Wales lead environmental protection legislation, the Protection of the Environment Operations Act, says about the sort of considerations that the court has to take into account when sentencing. And they're quite similar, but there are some differences which I won't linger on. I'll just note that the New South Wales legislation does specifically require the contemplation of the extent of environmental harm caused or likely to be caused, and I think that comes to one of the presentations tomorrow. Practical measures that have been taken to prevent, control, or mitigate the harm. Foreseeability is important. The extent that the person committing the offense had control, and whether or not they're acting under the direction of an employer or a supervisor. There's also several other factors the court can take into account, and of course the criminal law principles that have been just mentioned by John, of proportionality, even-handedness, totality, all of those things are also very important in sentencing decisions. Okay. The Crime Sentencing Procedures Act of New South Wales also has specific aggravating, mitigating, and other factors that are applicable to sentencing decisions. Okay. Oops, I'll just go back up for a sec here. Okay. The traditional approach in Australia, just like in Canada, has been, of course, to use custodial sentences and fines in response to the sentencing of environmental offenses. Oops. There we go. And of course, we look to the legislation to see what the upper limit of the sentencing judge's discretion is. We look to the legislation to get an understanding of how serious the legislature views the criminal conduct. In New South Wales, as in most Australian environmental legislation, we have tiered offence provisions, not tiered in accordance with who the offender is, although the penalty limits recognize who the offender is, but tiered on the basis of intention. Tier 1 offences are when there's intention or negligence, are mens rea offences. Tier 2, strict liability offences, and then Tier 3, sort of penalties and notices generally of absolute liability. And over time, particularly over the last 10 years, the fines have escalated significantly, the maximum fines. And the justification for doing so is made explicit in 2005 in the second reading speech of the amendment to this Act, where it was said that there was a need to maintain the original deterrent value of the penalties. So the courts and the legislatures have continued to emphasize the need to deter, again, not only the offender, but the need to design penalties that deter more generally. But of course, all those subjective and objective factors have to come into consideration in determining what an appropriate sentence is. Proportionality, even-handedness, as John has mentioned, together with other subjective factors, may mean that in fact the penalty is not at a level where it would serve the purpose of general deterrence. And while the ultimate deterrence is probably a custodial sentence, those sort of sentences are rare in Australia. Much more common is the imposition of a fine. But even with them escalating fines when they're not otherwise affected by those proportionality or even-handedness considerations, there's still particular concern for corporate offenders who are able to absorb fines, even which may seem large in comparison to historical fines, the ability to absorb fines simply as a cost of doing business. Or perhaps in situations where the corporate offender may stand to profit from the commission of an offence. And in Australia, the particular concern there is the clearing of native vegetation and also waste offences, disposal of things like asbestos, where it's much cheaper to dispose of it improperly rather than properly and bear the fine. So there's this concern about how we deter corporate offenders. And then at the other end of the scale, as I think Rebecca mentioned, when we have individuals who don't have the capacity to pay, the subjective factors will often mean that there's nominal fines, which again have no real deterrent value. So in Australia, the rationale for moving to creative sentencing options has largely been to think about how we can provide, in these circumstances, more socially acceptable outcomes. To deal with situations where fines and custodial sentences are either inappropriate or insufficient in the circumstances. Okay, so this is just a kind of summary of the kind of creative sentence options that are available in the New South Wales legislation. They look pretty similar to what you might see in some of the Canadian legislation and in most of the Australian legislation. But it really is New South Wales and Victoria, those two states, that are making the most use of these. So, publicizing the offence, carrying out specific enhancement or restoration projects, undertaking environmental audits, paying funds into the New South Wales Environmental Trust. And I should just note that that trust, in any event, is replenished each year by an index $13.5 million from consolidated revenue, so not necessarily dependent on finding other ways to redirect that money. Attending courses and training, preventing, restoring, abating harm caused, compensating for expenses incurred, paying investigation costs, revenue stripping, repaying any monetary benefit, and also community service orders that comes from another general piece of legislation up to a maximum of 500 hours. So all of these orders are available in addition to or in lieu of monetary penalties or custodial sentences that might otherwise be imposed. And again, these no doubt look pretty similar to Canada. But what's interesting, I think, is if we look at the Environmental Protection Authority, who is the lead agency who can commence prosecution, as can any other statutory authority, and as can, again, harkening back to Justice Stewart's comments, as can any person with leave of the Land and Environment Court. But looking at their guidelines on the sort of, the EPA's guidelines on the sort of circumstances in which they'll seek environmental court orders, you can see that the kind of orders that are available are divided into two categories. Orders aimed at restoring, preventing the recurrence of the offense, and then orders aimed at punishing or deterring offenders. So in that first category, all those kind of orders that put victims back into the place they would have been in, remove benefit, look to moving forward to better environmental citizenship from the offender, those all fit within those orders. The guidelines make clear none of these are meant to be punishment. Rather, they're intended to move the offender forward in a more environmentally acceptable manner. Deterrence comes down here. We have fines and custodial sentences are still there, but with them are environmental service orders and those publication notices. And so it's interesting to see them grouped like this, I think. The publication orders, according to these guidelines, are largely there in response to the criticism that fines alone do not deter corporations, can be an inadequate deterrent. Rather, as Justice Stewart noted this morning, the second most powerful deterrent is actually standing amongst your community and having them know how it is that you have been conducting your business. So that's why publication notices are placed there, okay? In determining whether those publication orders are appropriate, there's considerations like the culpability of the defendant, their environmental record, the threatened or the actual harm to the environment caused by the incident, but not after the fact cooperation or contribution in deciding whether or not a publication order should go forward. And the other additional creative alternative order there is our environmental service order. This is the order that allows the court to direct that a specific project be carried out for the restoration or the enhancement of the environment. Has to provide a public good. But the guidelines make clear that these kind of orders are intended to be punishing and deterring. And because of that, a publication order will always be sought in conjunction with an environmental service order. So it is the case, according to the guidelines, that the offender doesn't get to look like they're simply being a good citizen by undertaking or contributing to the performance of some sort of environmentally beneficial project. So that answers the criticism, in part, that Diane Sachs and others have referred to in Canada, that offenders are able to generate positive publicity for their apparent good works. And yes, having a stake in restoring the environment does presumably create positive momentum for companies to think about how they undertake their activities, and is a deterrence in and of itself. This publicity order acts to supplement that in a way that's noticeable in New South Wales. There's an article in the 2009 Journal of Environmental Law and Practice written by Elaine Hughes and Larry Reynolds, and they review several years of records from Alberta Justice and the Federal Department of Justice, and sort of categorize the kind of creative sentence orders that have been used between 1996 and 2006 in those two jurisdictions. And it appears that, well, their conclusion is that creative sentencing orders where funds were directed for specific projects with NGO partners were the most common form of creative sentencing order. Much less common were publication orders, which suggests that those two things don't necessarily go hand in hand. Okay, I'll just show you, I know this is probably really hard to read, but this is just one example, and every case, of course, turns on its own facts. This is a recent decision of the New South Wales Land and Environment Court, an order made in relation to a gold mine company, and I'll just read you briefly what the order is so you understand how they put these things together. First of all, the defendant was convicted as charged. They were ordered to pay to a Shire council the amount of $50,000 to contribute to the expansion of the council's effluent reuse project, which was in the vicinity of where the offence took place, but not necessarily connected or related to the offence. They were ordered to pay the prosecutor's costs and investigation expenses, about $5,000. The prosecutor's legal costs of $52,000, which is a very common order. And they were ordered to publicize in 3 newspapers, the Sydney Morning Herald being one that circulates widely in the state, notice in the form of the annex that I'll show you in a minute. And then the 6th order there says, or the 6th part of this order says, all future references by the defendant to its funding of the Cobar Shires Council's effluent reuse project shall be accompanied by the following passage. Peak Gold Oil's funding of the Cobar Shires Council's effluent reuse project is part of a penalty imposed on Peak Gold Mine by the Land and Environment Court after it was convicted of polluting waters, being a constructed clean water drain at the Peak Gold Mine, an offence against Section 120 sub 1 of the Protection of Environment Operations Act. So that's interesting, and you can reflect on that when Cindy comments on her experience with an Alberta Environment Order. This is just the appendix which specifies what it is that had to be advertised. And it's interesting what it says. It gives you a very clear picture of what happened here, and it might not be what you think, having just heard that order. Between the 24th of November and the 21st of December, mine tailings which contain contaminants, including cyanide and heavy metals, discharged into a constructed clean water drain at the mine site. The drain is generally dry, except during rainfall events. The pollution did not leave the mine site, and did not enter any natural watercourse or water body. So there was no actual harm, but there was the potential for harm, which is what the court was directing its order at. Okay, so as a result, they were fined and ordered to pay costs. Okay, so that's an example, I think, of a different approach to using these creative sentencing orders, really designed in a very focused way to deter. Last year, New South Wales EPA conducted a review of their alternative sentencing mechanisms and their environmental penalties. And they looked at all the other Australian jurisdictions and also New Zealand. And in their 2012-2013 annual report, they note that there's similar alternative sentencing mechanisms available in these other jurisdictions, but that some jurisdictions were using two other approaches. One, civil penalties, and civil penalties, not dissimilar to the sort of Quebec approach, have been used at the Commonwealth level in their peak environmental legislation since it was enacted in 1999, 2000, I think. But also, so that's civil penalties, but the other mechanism being used, and this is particularly in New Zealand, is restorative justice. So in 2002, New Zealand amended their Sentencing Act to specifically provide for restorative justice processes in relation to environmental matters. And there is, as Justice Stewart mentioned this morning, a natural fit here between restorative justice and creative sentencing. Because although creative sentencing, of course, focuses on deterring, it's also got this important restoration aspect when there's harm. And the focus then is about restoring the environment and remediating the harm, both to punish or deter the offender, but also to make whole the victim. And that's whether the victim is an individual, the community, future generations, or the environment itself. And so these different focuses coincide, and the focus on the victim leads us quite naturally to this concept of restorative justice. And just to note, John mentioned the experience in BC. Restorative justice can come at different points in the process. It can operate as a diversionary point, so that the matter never comes to court. And then there are these questions about transparency that follow. It can also come, though, following the finding of guilt, particularly a plea of guilt, but prior to sentencing. And it's at that point where it can really play a direct role in the exercise of discretion by the court, and in using the creative sentencing tools, the court can help to recognize, to the extent that things warranted, the conclusions of any sort of restorative justice process. So there's one such example in New South Wales. In 2007, Chief Justice Preston of the New South Wales Land and Environment Court was hearing a matter. The offender had pled guilty to knowingly causing or permitting destruction of Aboriginal objects, contrary to the National Parks and Wildlife Act. The offender knew that he should be obtaining a consent before proceeding with the activity, but because of financial considerations, chose not to. When the matter came to court, though, the offender pled guilty. And prior to sentencing, and perhaps more naturally because there was an Aboriginal community involved that led to restorative justice, an area where we have some experience, Chief Justice Preston asked the offender and the community whether they would like to participate in a restorative justice conference. The four essentials were here in order to make restorative justice appropriate. There was an identifiable victim, the Aboriginal community of Broken Hill. There was a victim who was prepared and willing to participate. There was an offender who was accepting responsibility for his criminal behavior, and there was non-coerced participation of the offender in the restorative justice process. All four essentials. So with their agreement, both of these parties did participate, the offender and the victims of Broken Hill did participate. And it led to a process of the Aboriginal community sharing information about the importance of place, the significance of the objects and that had been interfered with, and the importance of these things to the community in the area. And it allowed the offender to share the circumstances of his operations, the issues confronted by his business, etc. And it led to an agreement by the parties to work together to prevent the reoccurrence of similar offenses and to develop a voluntary conservation project and to train members of the Aboriginal community to work in this operation. The affidavit from the offender sort of conveys the power that this type of experience can have. He says, during the course of these proceedings, I have learned a significant amount about Aboriginal archaeology, the importance of the Aboriginal place. I have also realized how both Aboriginal objects and the Aboriginal place are more important to Aboriginal people than I had previously appreciated. I believe that I can confidently say that a situation such as the present will not arise again. Best case scenario. In sentencing then, so this is not behind closed doors. There is a 24-page decision, sentencing decision, and in the process of sentencing, Justice Preston says the fact of and the results of the restorative justice intervention can be taken into account in this sentencing process. But the restorative justice intervention is not itself a substitute for the court determining the appropriate sentence for the offenses committed by the defendant. Again, addressing those issues of transparency, proportionality, etc. Just to close then, since this decision, Justice Preston has written a few papers commenting on the role that restorative justice could play in allowing not just individual victims, but the broader community, future generations, the environment, represented in those circumstances by surrogate victims who vocalize their claim, to participate in restorative justice outcomes. He points to the tools for creative sentencing that can be used to put in place and implement any sort of restorative justice agreement by the sentencing court, making it possible for the court to order restoration, prevention of harm, etc., compensation, environmental audits, environmental service orders. All of those things could be employed by the court to achieve restorative justice outcomes, and then also overseen and monitored by the court going forward. And Justice Preston has noted that the use of these kind of processes can ultimately allow a more holistic approach to environmental crime, with the potential to transform relationships and behaviors, and finally provide a means to empower the broader community and the environment as a victim of environmental crime. So, wait and see what the EPA, what they do in relation to this notice on their website that other jurisdictions are using restorative justice. And I guess we'll wait and see whether New South Wales follows on with New Zealand's lead, and maybe other Canadian jurisdictions as well, to come up with creative sentencing options that also combine restorative justice, and maybe become the new back double full double full aerial trick that we heard about if we were watching the Olympics this year. So that's all from me.
Thank you very much. Just collecting. Okay, thank you. right. Start with this one. If the accused is acquitted under the POEQ, is it? Or, yeah. Provision for costs to the prosecution when the prosecution is successful, can the accused seek the costs from the state when the accused is successful?
That's a good question. I don't know what the cost provisions are in that act. It's definitely the payment of prosecution costs is considered specifically in the section 250, which contains the various creative sentencing options. And from my review of the last sort of 3 or 4 years of creative sentencing orders by the New South Wales Land and Environment Court is very, very common. Very common indeed.
Okay, we'll go to this one so you don't have to hold that too long. When restorative justice is used as part of sentencing, what is the procedure? Who selects the participants? Who facilitates? Is it script-driven? Do Crown Defense Counsel participate and or the judge?
Well, there's only been this one experience in New South Wales, and the parties agreed on a mediator. There have been, I think, in New Zealand in the last 4 years or so, there's been about 7 restorative justice processes, and the people who are in the room depends. There was one restorative justice process that involved pollution from farm effluent of a river, and there was representatives of the community speaking on behalf of the river. There's other times when people are themselves directly harmed, so it really does depend. And I think Chief Justice Preston is really pushing us to think about, he mentions Chris Stone to Trees Outstanding, to think about how we could have various various players in the room, including the environment. There has been some suggestion, I think Elaine Hughes in that 2009 ELPJ article suggests that the Crown should be speaking in the interest of the public in that regard. And perhaps there's a role there as well, but so it really does depend.
Okay. The next, is it your impression that the approach to environmental sentencing in New South Wales is being adopted in other Australian states? Has the Commonwealth government taken any initiatives in this respect?
Well, the Commonwealth government has a piece of legislation called the Environment Protection and Biodiversity Conservation Act, which only assumes responsibility through a cooperative federalism arrangement for matters of national environmental significance, so very particular matters. But there are a series of civil penalties and criminal offense provisions in that act. Obviously, the penalties are high, and there is the capacity for any person to seek an injunction if there's a breach of the act. So there actually is quite a bit of enforcement activity under the Commonwealth legislation. Other states, the state of South Australia and Victoria, are actually becoming quite proactive. The state of Queensland has introduced, I think their offshore marine pollution legislation was recently amended to include a $10 million maximum penalty in response to particular issues there. So jurisdictions are moving in different ways, but they're definitely proactive.
All right, time for 2 more short ones. A number of the options used in Australia, audits, restoration, abatement measures, seem to be somewhat open-ended as to cost, unless full estimates are available at the time of sentencing. Does this discourage agreement on creative sentences? And are there any caps on the expenditures that end up being imposed through such sentences?
There's not caps, and it's interesting, Will, a lot of those things, environmental audits can be ordered earlier in the process as well, or there's administrative procedures that could see those sort of audits ordered as well. There's not caps, and there is, in some instances, of quantification, and it often is far in excess of what a maximum penalty might look like, particularly under a Tier 2 offense. But in the interest of moving forward to compliance, I think motivated offenders welcome those sorts of orders, particularly if they're looking instead at deterrence orders and publication notices.
And finally, to what extent has the existence of a distinct new environmental court facilitated greater openness to alternative approaches to sentencing?
Well, definitely New South Wales and Victoria, which doesn't have a specialized court, have been the most proactive. I think generally New South Wales Land and Environment Court is seen across the board to be more proactive. They have the expertise, they have the jurisdiction to consider in certain circumstances matters de novo. They make a lot of planning decisions. And because of their expertise, they really take the opportunity to, if they're tackling a new environmental question or legal question related to environmental law, often they take the opportunity to write very, very long judgments which provide an excellent resource for everybody in the area.
Great. Okay, thank you very much, Erin, and thanks on behalf of everyone.